Report, please. The Honorable Supreme Court of the State of New Mexico.
Morning, maybe seated. Thank you. On S-1-SC-40187, State versus Perry. Sorry, you may enter your appearance and begin your presentation. You have 25 minutes.
Good morning, may it please the court. Nicholas Hart for Ms. Perry. This case presents a narrow issue, whether State versus Caps, which held that the smell of marijuana alone was probable cause to search a vehicle, remains good law after decriminalization of marijuana by the legislature. It does not for two primary reasons. The first is that the decriminalization of marijuana leads to a conflict between Caps and other principles of the principle of New Mexico law, that conduct that can be both innocent and unlawful, so if lawful and unlawful, cannot by itself be probable cause to justify a search. And this is derived from a long line of cases, both from this court and the Court of Appeals, which I pinpoint really to State versus Nice, which is 2006 NMSC 020. This is where we're dealing with that issue head on. The second is that the underpinnings of Caps is the automobile exception to the U.S. Constitution, which this court later rejected as repugnant to the New Mexico Constitution. Given those two issues, my belief is that Caps is no longer good law. To start with the decriminalization issue, the statute in decriminalizing marijuana took it from certain amounts of marijuana from a crime to a violation that would result in a penalty assessment. The state's position is that a penalty assessment remains a crime because of the process that comes after it. But when there's a penalty assessment is a fine, anytime there's some type of deprivation of property from the state, there's some type of process that follows. So the mere fact that someone who receives a penalty assessment could come to the court and challenge that fine is not enough to make it a criminal proceeding. Instead, what I believe controls is the New Mexico statute that makes clear that a crime is either a felony, a misdemeanor, or a petty misdemeanor. A penalty assessment is neither.
Mr. Hart, speeding is a penalty assessment, correct?
I believe it is, yes.
So does speeding give rise to probable cause to stop?
The issue here is not the probable cause to stop the vehicle itself.
I understand, but the issue is probable cause.
That's correct.
So what's the difference?
I think the difference is that the stop of the vehicle itself there is the enforcement of the penalty assessment. Right here, the stop of the vehicle, the search of the vehicle is not based on the speeding.
Why couldn't it be the enforcement of the penalty assessment for possession of a small amount of marijuana?
Because when a car is speeding, it is only speeding. It is nothing else. But marijuana, at this time, after decriminalization, had non-criminal purposes, and even after legalization is completely,
That's a totally different.
I agree.
Totally different question. Talk to me about NICE and the progeny that you discussed in your briefing. Those cases seem kind of easily distinguishable to me. They are all involve facts or circumstances that without question or any gray area at all is legal conduct. A box of Kentucky Fried Chicken, blood that can be attributed to anything. So you have this heavy reliance on NICE and its kin that don't seem to really answer the question here. How do you correlate the two? Because legalization had not happened. There are still amounts of marijuana that were a crime, were illegal. We're, bad conduct.
I think that one thing to start is, of course, we disagree that the possession was a crime, right? We do believe that there's this distinction.
But there were levels of possession that would be a crime in this small window.
That is correct, right? And that is,
Which makes it different than a box of Kentucky Fried Chicken. That's my point.
well, sure, but Anderson wasn't just the box of Kentucky Fried Chicken. The point of Anderson is that after he pulled over the vehicle, that the officer believed that all of these things, traveling from one state to another, sleeping
Purely
at the
legal
truck
conduct.
stop.
Purely legal conduct. I mean, there's no question. None of those events in a greater quantity would be a crime. They're all purely legal conduct.
I think, to me, the biggest issue in this and why I look towards NICE is that there is always in a probable cause analysis going to be some issue with the categorical rule, right? A probable cause analysis is looking at the totality of the circumstances, right? And in Anderson and Heidel and Sanchez and all these cases that we cite to, of course, the ruling, I don't think could be limited down to a single act. That's there. It's that the court looked at the totality of the circumstances, said that this innocent, otherwise innocent or lawful conduct stacked on top of each other is not enough to establish probable cause. I think that principle equally applies in this case. The so-called conduct that led to probable cause is the smell emanating from the vehicle. And when that smell itself is not a crime, right? The smell does not allow an officer to determine how something, the quantity of something. And that was kind of the issue in Sanchez, right? When we see a baggie of 2 pills on the floor, that could be criminal conduct. That's not typically the way prescription medication is stored. It's being hidden by that individual towards the floorboard. But the court in Sanchez said that that's not enough unless the officer could give something else showing that in that specific instance, either those pills were unlawful to possess or that there was some other conduct. And that's the issue. I think that applies well here, which is the smell alone when it comes to the penalty assessment is not enough because the smell alone can't talk to quantity. The smell alone can't talk to when it's coming from the vehicle and not from the person, because I think that part is undisputed here, can't talk to intoxication. So there's certainly instances where a smell of marijuana could contribute
Talk
to
to me
the
about the smell of
analysis.
alcohol then. The smell of alcohol is probable cause for all manner of things. And there's no indication with the smell of alcohol, what the quantity consumed was or whether it was consumed at all. And so how do we distinguish those two things? You're saying smell of marijuana out of bounds, because that by itself isn't enough for anything. Well, then the argument that will follow is smell of alcohol is insufficient for the same exact reason, because not all alcohol is going to meet any kind of criminal standard. You have a drink. Nothing illegal about that. A bottle of alcohol breaks in your car. Nothing illegal about that. So how do we, I mean, if we were to go the way you want us to, what does that do with respect to alcohol, the smell of alcohol in a vehicle?
I don't think that that changes the issue, because first off, we're not dealing with, I think that your question, Your Honor, raises two separate lines. The first is the intoxication issue, which is if there was any evidence at all or any allegation at all that the smell was emanating from Ms. Perry herself. I don't know that we're here in the Supreme Court on the certified question. It's a much different question than the officer just saying it's emanating from the vehicle. I think that there are other issues with.
Oh, we see case after case after case where it's just the smell of alcohol. It's not emanating from the person. They roll down the window, the officer says, I smelled alcohol, and then of course they always add their eyes were glassy. Goes without saying, they're gonna say that. And that is probable cause for all manner of things. And so here you're saying the smell isn't enough for anything.
I think that's what leads to the second part
Okay.
of your question, which is we do have misdemeanor offenses for open container crimes, right? Which was not.
But I use mine, the container breaks. That's not open container. You have one drink. Smell of alcohol. I mean, people process alcohol differently. Not illegal. So it's very, very similar. And there's no penalty even to be assessed at that point. That's just purely legal conduct, but it's still probable cause to continue to do something under our jurisprudence.
For the having one drink part, yes, we have this benchmark that we use where if you are above it, it is.
But you don't know that at the time the officer stops you.
Well, what we do know at the time the officer stops someone is there's some type of driving that shows impairment, and that's actually the standard, right? It is possible, although it's very unusual, right, that someone could be impaired from the lower blood alcohol content that would otherwise prevent them from operating a vehicle. And by the time the officer gets to that point, the officer has all of these traffic issues that the officer believed the individual to be impaired. And then there is the smell of alcohol. So it's not, you
get pulled over for going 5 over. They're not pulling you over because of impairment. You roll down your window, the officer smells alcohol.
Sure, Your Honor. And again, I think the issue is
That's
here,
this case.
I think that the issue that comes from is the issue that I brought up before, which is having a categorical rule when it comes to determining probable cause, right? And that's
But
what
you're
CAPS
overlooking, I
is.
think, is the statute at the time of the stop says it is unlawful for a person intentionally to possess. Period. It's unlawful. There's nothing saying it's not talking about a penalty assessment down the road or what happens after the fact. It is unlawful to possess.
So, Your Honor,
So you're saying even though it's unlawful to possess, probable cause that there's something unlawful there is not probable cause to search?
no, Your Honor, I think that when it comes to unlawful, the question is then that unlawful has to be defined.
No, it says it's unlawful. It's a violation of the law. It's not consistent with the law to possess.
I understand, Your Honor, but it's also unlawful to fire someone for a discriminatory reason. It's not a crime, right? So when just using the word unlawful, I think unlawful then needs to be defined. And in defining unlawful, the question
Saying
is
it's
that it's
unlawful to fire somebody that's not a crime, but it is unlawful to possess marijuana.
the question is it criminally unlawful or civilly unlawful?
It says unlawful.
I understand, and then that begs the question, criminally or civilly.
So do we, in order to agree with you, do we have to do we have to say decriminalization is the same as legalization?
No, I think though that if you conclude that a penalty assessment is still criminal, then Yes.
Or that it's different from legalization?
Different from legalization, then yes, we lose. Right? This depends on the fact that as a penalty assessment, as being decriminalized, we're taking it out of the criminal sphere and moving certain amounts of possession of certain amounts of marijuana.
And haven't a large number of cases faced with this same exact question landed on decriminalization is not the same as legalization, and therefore the smell is probable cause? There's a litany of cases spelled out in Robinson versus State that walk through the large number of cases who ruled that way.
And there's a large number of cases that rule the other way.
I beg to differ with your assessment of the counting, but there are a number of jurisdictions who land with that. Following Florida versus Harris, decriminalization and legalization are not the same. Why should we depart from that?
I think one, Your Honor, is we do have to apply it under through the lens of New Mexico law, that we do have to apply it through this penalty assessment process. And that's what I think makes it more similar to Massachusetts, Pennsylvania, Michigan, the cases that I explained and cited in the brief in chief, right? Because those are cases where it took something from being a crime to making it a fine. That's what essentially a penalty assessment, my argument is a civil fine. So I think that is the difference between some of the other cases that we discuss. I think there's a difference between a statute that says the police are not going to arrest you, or you're not going to be charged with a crime when it's below a certain amount, versus saying it's now a fine instead of a crime. That's the distinction. To move quickly to the next part of it is, I think that even if the court disagrees with me on the general issue of whether decriminalization has moved CAPS in the wrong way, I think that CAPS still needs to be re-examined, because after CAPS, this court rejected the legal underpinnings, the automobile exception to the United States Constitution, as repugnant to the New Mexico Constitution. And even though the state seems to disagree with me that CAPS is an automobile exception case, paragraph 11 in that case makes clear that the officer's right to search was dependent upon the officer's belief that the automobile contained evidence of a crime, right? So it's clearly, in my view, an automobile exception case, which just doesn't apply here. The officer still should have if you believe there's probable cause, the officer still should have sought a warrant. There was no exigency, there was no impoundment. There was threatened, right, to impound and inventory the vehicle, but that's not what was done here. Instead, we have this reliance and the facts that are looking solely towards the search of the vehicle to find what they believe to be fruits of criminal activity, right? Possession of marijuana. I think that is no longer sufficient under New Mexico law to justify a search. So I think, to me, that's another reason that this court needs to revisit CAPS. Now, I do also think that even though we're in a different world than legalization, obviously, right? I mean, it's a different statute.
The certified question encompasses the second issue you're raising. I mean, I'm just reading if we just stick to the actual question as narrowly as possible, then do we need to get into this second issue you've raised regarding the automobile exception?
I think that there's certainly a narrow reading of the certified question where you could say this shouldn't apply at all, but the certified question does ask whether CAPS remains, good law. And if there's another reason that CAPS is no longer good law, then I think the court should take the opportunity.
But that's just on the question of a warrantless search, right? I mean, it's established. We've rejected that doctrine. So you're saying reverse CAPS just on that? Just go out and reverse CAPS on that? Is that what you're suggesting?
I think that that's a legitimate basis to say CAPS is no longer good law, that I think it was Cardenas Alvarez effectively overruled CAPS, and the Court of Appeals need not continue to apply.
Your client consented, right?
Consented after the different steps that we were contesting were the unconstitutional extension of the stop.
I'm sorry, say it again.
So there was eventually consent. There's no issue in the Court of Appeals because of the way the case was decided.
I apologize. I thought you were telling us the context of this case is that the officer went ahead and searched the vehicle with exigent circumstances. My understanding is your client consented to that. We're now arguing that was coerced, I assume, right?
No, Your Honor, what I'm saying is the automobile exception doesn't apply because doesn't seem to be any fact to show that there would have been exigent circumstances if that was the procedure that was being followed. Not that there were exigent circumstances. If there were, the search is totally valid.
That he consented.
But again, Your Honor, what we're challenging is not just the search. The search is part of what is being extended beyond just writing the ticket and sending Ms. Perry on her way. And there's a long line of cases that the probable cause requirement is not just the search. The probable cause is to extend the stop in order, to get to that point where the search happens. So the fact that she later consents after the stop is extended to engage in all of this questioning about whether there's marijuana in the vehicle, after she's removed from the vehicle, after another officer is asked to the scene, the consent didn't come before any of that, right? And the question still has to be answered whether there was probable cause for the officer to do those things other than write the ticket and tell her to have a nice day. Just to kind of finalize in the last couple of minutes, I don't think that the state here is correct on its reliance on the advisory opinion doctrine or constitutional avoidance. This is just not like those cases. When we look at Bell Telephone, that's a case where a company was trying to get a decision beforehand saying that this anticipated revenue ruling may affect us before the revenue ruling happened. That's not what's here. Ms. Perry was actually stopped. She was actually arrested. She was actually convicted of a crime. I think that El Paso gets them closer, right? But that would require the court to say that the legalization statute, the 26-2C25, was some type of intervening legislative rule that would apply in this case. I think there's two problems with that. The first is that it's obviously under a different statutory regime than what we're dealing with. But the other is, while I think it's admirable that the legislature is making those determinations, these are constitutional determinations, and I do think that there's going to have to be a question, down the line of whether the legislature has the power to say what equates under the totality of the circumstances to be probable cause or not under the New Mexico or the United States Constitution. So I still think that even if we're doing that there's an issue here. And for the constitutional avoidance, I just don't believe, Your Honor, there's a constitutional avoidance issue. There's not a statute rule. There's nothing that the court could rely on short of the constitutional issue that's before the court to make that decision. Because of that, if there are no other questions, we would ask that the certified question be answered, that CAPS is no longer good law, and that the order of the district court should be reversed.
Thank you, Mr. Hurd. Morning, Mr. Van. So you may enter your appearance. You have 30 minutes.
Good morning, Van Snow for the state, and may it please the court. This court should not use this case to determine whether the smell of marijuana standing alone could constitute probable cause before legalization. So I'd like to start with some of the questions that came up during the other side's presentation. Several justices asked some difficult and thorny questions about, well, okay, say we agree with you. What does that mean for other penalty assessments? What does this mean for the state's ability to enforce DWI laws with other substances like alcohol? These are some thorny and difficult questions. And that leads in naturally to the state's discussion about the more justiciability sort of concerns. That if this court is answering this question, it's not just about marijuana. There could be knock-on effects for the probable cause standard generally. So this court is risking destabilizing that area of law to answer a certified question that isn't actually necessary to decide the legal dispute between the parties. That's a good sign that this court shouldn't answer that question. So a good way of showing that this is actually an advisory opinion is to sort of put the question to the defendant's case that the state posed in its answer brief. So let's say this court says that the smell of marijuana standing alone cannot constitute probable cause and sends it back to the Court of Appeals. The Court of Appeals can and should still affirm the district court because regardless of whether there was regardless of whether the smell of marijuana alone could constitute probable cause, there were still plenty of other facts. Some facts that the defendant can't get away from is driving. We have driving plus the smell of marijuana. We have driving poorly plus the smell of marijuana. We have driving poorly plus marijuana plus seeming admissions that there probably is marijuana in the car as well as a needle.
Right, so I follow all of that, you know, but here the trial court in its order relied solely on the smell. And so while there may be fair questions on remand for the Court of Appeals, I don't think it really, it doesn't persuade me that this isn't justiciable at this point because of what the trial court did, which is just ignoring all of that, relying on caps and saying the end. That seems to be problematic for your argument about don't get there yet.
Oh, yes, Your Honor. And I think that that is where the right for any reason sort of analysis comes in, which is the analysis that the state proposed that the Court of Appeals take. And here, probable cause is a legal question. And there is a more factual development that has to happen. And it wouldn't be unfair to use the right for any reason doctrine because Officer Green told the defendant it was the smell of marijuana, your admissions, that she was basing her application for a search warrant on. Officer Green told defense counsel at the suppression hearing.
Isn't it fair for the Court of Appeals wanting to know if this court is to conclude that caps is still good law, makes the Court of Appeals job really easy.
Oh, yes, Your Honor.
So isn't it fair for them to ask that question, saying, you know, we don't want to tinker with caps unless you tell us what you think.
Yes, Your Honor.
So in the certified context, that justiciability just doesn't grab the same way.
Sure, and I understand that certification is different, but oftentimes, and so it's certainly fair for the Court of Appeals to want to know an answer. Another case is probably the better example for the court to ask that question. And also, I think that highlights probably the small universe of cases we're talking about. Defendant is claiming that this is just post 2019 to 2021, that there would be this different constitutional rule. And the legislature has crafted a rule to handle cases going forward. So although the Court of Appeals can certainly be grappling with some of the thorny issues that we've come up with, again, this may not be the best case to come up with a constitutional rule for this very narrow window of cases.
But the right for any reason doctrine is really discretionary on the Court of Appeals. And your examples would raise two concerns for me. One, did the state know below that there were going to be these other issues, like maybe the driver was impaired and all that? And more importantly, did the defense have an opportunity to cross-examine or address some of these other issues? And I don't recall the answer, but if the district court just relied on smell and caps, I would be somewhat concerned about going beyond that. So
at the suppression hearing, when defense counsel was cross-examining Officer Green, She pointed to both the smell of marijuana as well as, I believe, the admission. I think there was a lot of focus on the needle. In fact, that was one of the main areas that defendant was challenging with his motion to suppress, was all the questioning about the needle. Initially, in its argument before the district court, the state just pointed to the smell of marijuana alone. But then the district court asked the state to clarify which facts are you asking me to look at here. And the state pointed to the smell of marijuana, the admissions, and I believe he said, and everything else. And granted, that could have been a little more specific, but the issue and the facts here were fully raised and developed. This was just a question about what inferences do you draw from the facts. So although your Honor is certainly correct that it's a discretionary doctrine, this would be perfect place where if the Court of Appeals is grappling with this question, doesn't know what to do with these narrow universe of cases, then like in this case, when it doesn't have to reach the issue, that's an appropriate way to decide cases because it's avoiding these kind of thorny, bigger picture issues about, well, what did the probable cause standard mean? What do we make of that standard articulated by the United States Supreme Court in Florida v. Apologize, this is in my brief, Florida v. Harris, that probable cause to search exists when a person of reasonable caution would believe that contraband or evidence of a crime is present. So if those are distinct concepts, and marijuana, even though possessing it was illegal, doesn't count as contraband, what does count as contraband? So then we're in an awkward spot of, we're saying a portion of a United States Supreme Court case defining probable cause doesn't mean anything. That contraband.
So what about defense's argument that we should be viewing this differently under the New Mexico Constitution?
Yes, Your Honor. And that's where kind of the constitutional avoidance questions also start to kick in. So the New Mexico Constitution oftentimes has been interpreted as having broader search and seizure protections, particularly in the exceptions to the warrant requirement. So this isn't a warrantless exception requirement. And that's at the heart of the confusion about CAPS being an automobile exception case. It was, but the question of probable cause was different.
It was exigent circumstances was really the focus, wasn't it?
Yes, Your Honor. So a threshold question that the court had to answer before applying the automobile doctrine was there probable cause? And that's the point that defendant wants overruled, not the later holding that in this case, the search of those garbage bags were warrantless. So this isn't a classic case where the New Mexico Constitution has been interpreted broadly, reflecting a broader state preference for warrants. This is purely a question of probable cause.
Yeah, and I mean, to me, and I'll ask you this so that Mr. Hart can address it as well. This is our jurisprudence has been largely in this arena has been very consistent with federal interpretation.
I think that's largely correct. I think there may be, I wanted to say I thought of a possible exception this morning about probable cause, but I can't recall it offhand. So in general, I believe it is. So we have here some difficult questions that would counsel relying on the jurisprudential points the state is pointing out, but even getting to the merits, it's important to keep a couple things in mind here. The first is that the burden's on defendant to show that long-standing precedent should be overruled. This court doesn't do that lightly, so he needs to show pretty clearly that CAPS can't be good law anymore, and he's just failed to make that showing. And that's because CAPS is the kind of natural outcome when you take the probable cause standard and you apply it to this smell that's, at the time, highly characteristic of pretty much only something that's illegal to possess. There's the open and difficult question on what exactly the legislature meant to do with the purported decriminalization that in the same statute refers to itself as a conviction and allows further process. That's a tough question, but it's clearly contraband. And in addition to that, it's important to go back to that probable cause standard. You don't need to prove that a crime was committed. It's just enough for a reasonable person, essentially, under the circumstances, to think that there's contraband or evidence of a crime present. So CAPS, even under the 2019 decriminalization, is just what you get when you apply the probable cause standard to marijuana. So It's important also to note that other states have come down really differently on this. As Your Honor pointed out, the best cases for a defendant had to do with full legalization, which is clearly different. The state's not taking the position that after legalization, the smell of marijuana could constitute probable cause. The legislature has answered that question. Two, State v. Perry and Robinson v. State had very thorough analyses on how limited decriminalization doesn't fundamentally change that standard. Probably the closest case left that defendant cites is the Massachusetts case. There, one thing that's distinguishable is that the Maryland statute was a lot clearer. It was pretty clear the Massachusetts, excuse me, that the Massachusetts legislature really did intend to create this wholly civil thing, an enforcement mechanism. And that's not what the legislature unambiguously did. So we're left with apps being a correct and sensible application of the probable cause standard of marijuana, even under the governing law at the time. We don't have a consensus of other states that are saying caps is wrong, that sort of outcome is wrong. So what else are we left with? We then have defendants' 2 points that he relied upon at oral argument today, claiming that there are conflicts with precedent. As questions from the bench noted, those cases are distinguishable because they all involved potentially purely legal conduct. And even with decriminalization, marijuana was still contraband. So it doesn't fall under or do any violence to those cases. On the prescription example, I think that's worth noting. Not only is it, oh, never mind, I've covered that. And then the automobile exception. And again, that's mixing two unrelated concepts. There's the question of probable cause, which is what this court is dealing with. And then there's the separate question on whether you could do a warrantless search under the circumstances. So taking all of those reasons that defendant has offered to overturn this long-standing precedent, she hasn't made her required showing. So unless there are further questions from the court, the state respectfully requests that this court either answer that the smell of marijuana could constitute probable cause or dismiss the certified question.
Thank you.
Thank you, Your Honor. I think that one thing that I failed at making clear that before the court is that the issue here is not that Ms. Perry is asking that the smell of marijuana can never be probable cause. It's not the issue. The issue is whether CAP's ruling that it alone can be probable cause is still good law. Right? So if the court agrees with me that the smell alone, that a categorical rule that once you smell marijuana, you get to search, is no longer good law, then what we're left with is the typical totality of the circumstances analysis of what happened in each case. We're not asking, and this is actually addressed in footnote 2 on page 11 of the brief in chief, saying that we're not asking for the categorical rule like they have in California, that it could never be probable cause. Also, the state's rebuttal argument, I think, shows the difficulty in that is underlying CAPS when it comes to the constitutional reliance on the automobile exception. CAPS is a pre-Gantt case. It was a Carroll under the Carroll analysis, and Carroll required a 2-step analysis for the automobile exception to apply, both that there would be fruits of the crime and that there were exigent circumstances. That's not the same standard that applies today in Arizona versus Gantt. The Supreme Court has even narrowed, the US Supreme Court has narrowed some of these issues. I think that further shows why we just need to scrap this case, get rid of CAPS and return, say it's not good law, and return to the totality of the circumstances argument. Because even in federal court, the arguments that were made under Carroll in CAPS would no longer apply. They haven't applied since 2004, right? So there's all of these issues in the legal underpinnings of that argument. And I think that when we put all of this together and we look at the district court's ruling in this case, right, the basis for it was simply that smell alone was enough to merit the search. That clearly derives from CAPS, even though CAPS is relying on other federal cases. And that should no longer, in a world where there was decriminalization, where the smell of marijuana may not have been a crime, should no longer be sufficient that the smell alone is probable cause. And the court needs to go no further in its analysis or in overruling CAPS. So we would ask that the court make that decision and send it back to the Court of Appeals with that made clear that CAPS's role is no longer applicable. Thank you.
Thank you, Ms. Hurt. Right. Like, thanks State and Defense for their presentation. Oral written in this case, 40187 is now deemed submitted. Court is in.
In the